and they will be heard.
People against Dennis Kozlowski.
Ready for court, please?
People against Mark Swartz.
Ready for court, please?
Mr. Norma. Good afternoon.
Good afternoon, Your Honor. May I reserve 4 minutes for
4 minutes, certainly.
Good afternoon, Your Honors. May it please the Court. My name is Nathaniel Marmer, and I represent Mark Swartz on this appeal. Your Honors, what occurred below was a fundamentally unfair trial that resulted in the conviction of Dennis Kozlowski and Mark Swartz for stealing money that they had earned under their bonus plan. What made this trial unfair was that Tyco was allowed to engage in a one-sided and opportunistic waiver of privileges in a manner that distorted the evidentiary record. In evaluating that claim, I think there are 2 overarching facts that it is important to recognize. The first is that the evidence in this case came almost exclusively from one source, and that is Tyco. So the documentary evidence at trial consisted of the books and records of the corporation. The testimonial evidence at trial consisted of witnesses from Tyco, its officers, its directors.
Are you addressing the subpoena in particular, Mr. Marmer?
I am, Your Honor.
And you do not object. You agree that Gissendanner is the applicable standard?
Well, I agree that Gissendanner provides at least a threshold inquiry that's important here. The appellate division relied solely on Gissendanner. I think we easily satisfied Gissendanner. It really wasn't that much of a debate in the lower court. The real issue in the lower court revolved around privilege and privilege waiver.
But it was determinative in the appellate division.
It was determinative, and I believe wrongly so. And to begin with, the appellate division said that the trial court had not abused its discretion in denying enforcement under Gissendanner. To begin with, I don't believe that the trial court exercised discretion under Gissendanner. Instead, it found that the material we were seeking was privilege, and the privilege had not been waived.
Have you received all the documents that the prosecutors had in their possession?
To our knowledge, and we certainly don't challenge the fact that whatever was turned over to the people, we got. There are 2 types of selective waiver that appear in case law. One type
So it's only the documents that are in this privilege log that you're seeking, correct? These
documents on the privilege log we were seeking, and of course we're
And you had received some of those, have you not? I think about a half a dozen of those.
There are a few that we've received, but I think the focus has always been on what are the key statements of the directors who were the primary witnesses for the people at trial. Those appear, I believe, at 47 and 55, those entries on the privilege log. And those are 28 pages of notes.
That's John Fort's statements and
Well, it's not just John. I believe it's all the director,
Lena,
4 of
Hessman,
the 5
Slusser, et
directors
cetera. Okay.
who testified at trial. These were their statements to the internal investigators. They are the earliest statements of the key witnesses at trial. They were made, they addressed the key issues at trial. They were made at a time when the objective evidence suggests they were not antagonistic to Mark Swartz. They may be supportive of Mark Swartz. At that time, they were keeping him on as CFO of the company. He was exercising the authority of that position. He was signing Sarbanes-Oxley disclosure statements. All of
But what evidence is there that these documents, just staying with these, would have been exculpatory as far as your client was concerned?
Well, certainly under Gissendanner, the standard is not that we have to show they're exculpatory, but that we have to identify specific statements that show that they have the potential to be exculpatory.
Correct.
First of all, I believe most courts, and even the case law, suggests that simply identifying prior statements of key witnesses is probably enough to get you in a subpoena enforced.
That certainly shows relevance.
Certainly shows relevance. And remember, Gissendanner is really a case about showing exculpatory documents of material and exculpatory in order to overcome a confidentiality claim. In that case, they were confidential police records. So if we're putting aside the issue of privilege, there's no question of confidentiality here. We're just looking to enforce a subpoena. But even so, the facts here demonstrate that the directors, at the time that they made those statements, were taking actions that were wholly inconsistent with the belief that Mark Swartz had stolen money. Because at the time those statements were made, August 12th and August 13th of 2002.
Wasn't he asked to leave on August 13th?
He remained as CFO of Tyco until mid-September. He resigned his position as a director. During that time,
The day after one of these interviews, correct?
I believe it was in early August that he resigned, sometime a couple of weeks before the interviews. The day after the interview, he signed the company's 10Q. That is to say, he was the Sarbanes-Oxley designated officer of Tyco, attesting to the accuracy of the financial statements of this company the day after they made these statements. The day after the directors made these statements, they paid to Mark Swartz $50 million. That's not the kind of action that someone would take, a fiduciary of a company who believes that their CFO has just pilfered $50 million.
That argument, I understand, but what I thought you were talking about with the subpoena, and I think you are, is that there are certain circumstances under which objective evidence, forget attorney-client, stuff, but objective evidence like in personal injury actions, measurements of an accident scene that can no longer be duplicated, or tests on an object that can no longer be repeated because of the destruction of the thing. You're saying these are objective statements that I need because I can't defend myself without them.
That's absolutely correct. They were made at a critical time. They're made, and the pressure that the prosecution had over Tyco and its directors was enough to make this company basically do what the prosecution wanted to do.
Do you dispute that you could have interviewed these people, admittedly, at a later time?
I have two. We do dispute it because each of the directors was asked, would you meet with defense counsel or did you meet with defense counsel? The answer was no.
Well, was it did you or was it would you? That is,
It may have been did you. I don't know if the question was framed. But in any event, Your Honor, it didn't matter if we were able to interview those directors at a time after their motives to lie had changed. We could have interviewed them at a time when they were telling the DA's office, oh, sure, Mark Swartz stole the money.
But at the time of the interview, at the time of the memorandums that you're looking for, the company had already hired David Boies. David Boies had already confronted Mr. Swartz. He'd already discovered the $25 million. Wasn't there a rather intense, even though he was still the CFO, wasn't there a rather intense distrust between the directors and Swartz at that point?
I don't think so, Your Honor. I think the evidentiary record was that there was extreme pressure by the district attorney's office on Tyco. To get rid of Mark Swartz, and that was sort of developing over this time.
And they were doing their best to respond by getting rid of them, weren't they?
Actually, Your Honor, they mutually agreed to part ways and gave him $50 million.
Yes, but they might have been obligated to pay him $150 million.
Your Honor, I don't know the best analogy, but if I or maybe a member of this Court had their secretary steal $40,000, I wonder how much longer that person would be at that company. I wonder if the clerk of this court was found to have stolen filing fees, $50,000 in filing fees. How much longer that?
All eyes turned to Do you know something we don't?
I don't know something we don't, but I do know that this court wouldn't allow him to certify the filing fee.
Leaving the clerk out of it, but if your secretary had a $200,000 golden parachute, you might talk to her for a while before you fired her, wouldn't you?
I think that the court, if the court is saying that I have to be able to prove what is in those documents, the answer is I cannot do that. A defendant cannot show what he does not see.
Can you show that the substance, that the content of the documents, I realize not the documents themselves, but the content of those documents was shared with the prosecution?
I can show that I can't show specifically what was and was not shared. What I can show is that at the outset of this case, this investigation, the people and Tyco entered into what they call a common interest agreement, what we defense lawyers would call a joint defense agreement. The only purpose of that agreement is to allow the parties to share information between the two of them to the exclusion of outside parties. Throughout this case, we know that Tyco allowed people to go down to the district attorney's office, its lawyers, and give information to the DA that we did not have.
That gets you, it seems to me, into the area of Rosario. And you don't, if I remember your brief right, don't argue a lot about that, but the amicus does. Right. And is one of your points is if you have a joint defense agreement between a party and in this case the people, that Rosario would apply to the other partner in that joint defense agreement?
We don't make that argument. I think we potentially could have made that argument. It would be a question of whether that in some sense, Tyco became the agent of the prosecution because of that close connection. I don't quite make that argument in my brief, and so I don't argue that it's really Rosario per se. Obviously, these are prior statements of the key witnesses, so they are Rosario-like. All we are trying to do is enforce a subpoena. And if I could just come back to Judge Smith's question and some of the other questions that have been posed, this is what Gissendanner says about accessing this kind of material. After summarizing the cases,
Which page are you at?
of Gissendanner, I believe at page 550 of the New York report, what it says is the thread that runs through these cases does not indicate that a defendant must make a preliminary showing that the record actually contains information that carries the potential for establishing the unreliability of either the criminal charge or of a witness upon whose testimony depends. The decisions erect no inviolable shield to prevent the discovery of what might turn out to be relevant and exculpatory material. What they do call for is the putting forth in good faith of some factual predicate which would make it reasonably likely that the file will bear such fruit and that the quest for its contents is not merely a desperate grasping at a straw.
And what here goes especially to exculpatory material?
Your Honor, the key issue for us, the key issue at trial, came down to whether these directors were telling the truth, whether they had said whether they had approved or not approved the disputed bonuses here. We believe that their conduct strongly supported Mark Swartz all through the time that they knew of the bonuses. It is hard to imagine, in our view, that these directors knew of the bonuses and yet were taking the kinds of actions that they were taking with respect to Mark Swartz. So the question is, what were they saying to Boyd Schiller on August 12th? Were they saying to Boyd Schiller, no, we didn't approve those bonuses? Well, that should have set off a red light. You're telling me that Mark Swartz stole $50 million? What would a director have done? What would Boyd Schiller have done?
The board didn't have to pass resolutions to approve some of these bonus payments, if in fact they knew about them?
Well, there are certainly issues about whether the bonuses were certified and things like that. I think in terms of that, the key part of the bonus negotiation, the key part of the bonus plan occurred not at the end of the fiscal year, but at the beginning, because this was a non-discretionary bonus plan. And what that means is at the beginning of each year, the parties negotiated what limits, what thresholds would be met, and therefore what the payouts would be. That occurred at the beginning of the year. What occurred at the end of the year was the ministerial paperwork that allowed, that paid it out. But there's no doubt that if the earnings of the company were at X or Y or whatever, that Mark Swartz and Dennis Kozlowski were entitled to that money.
But not until the end of the year.
Not entitled to the end of the year, although the board did have the authority to advance that.
Well, some of the loans, et cetera, they were during the course of the year.
I mean, the people make much of the fact that, well, some of this was paid a month early or sometimes more than a month early or whatever it is. But the question of entitlement below turned on whether under the plan terms, these defendants were entitled to that money. And it's absolutely clear.
And the purpose that they put that money to is not part of this case, in your estimation? Or weren't the KELP payments supposed to be to reimburse for income tax payments?
Well, there was an argument about that.
As opposed to using the funds for the multitude of expenditures that were undertaken here?
Well, I think it was widely known that KELP, which it doesn't say it has to be used for income tax. It says may be used for income tax. It says primarily should be used for income tax. That program certainly was used where taxes had been paid. These were substitute loans. It is quite confusing.
But for a loan of $8 million to buy a Renoir, are you really saying that was okay?
I'm not arguing the KELP point here, per se. I mean, what was done with the money, whether these were proper loans these were disclosed, the amounts of the loans were disclosed. I mean, what I'm arguing is that
They were disclosed on the proxy statements? I thought they weren't.
the amounts of the KEL loans were disclosed in the proxy statements. And I think the purpose the question may have been what purpose they were put to. But my point is that let me just read, for example, the key dispute on two of the biggest bonuses, the two biggest bonuses, was whether non-recurring gains were included. That was the dispute. Here is what the bonus plan says on that. EPS means the fully, I'm sorry, from page A449. This is the bonus plan, 1994 bonus plan. EPS means the fully diluted earnings per share as reported in the company's annual financial statements. everybody agrees that if you look at the financial statements, that number includes non-recurring gains. I have yet to hear from the people what their answer is. If under 1994 bonus plan, non-recurring gains are included, because everyone seems to agree that they are.
And you're saying if you include non-recurring gains, all the, I mean, the $37 million loan forgiveness becomes legitimate?
Absolutely. This is what
Didn't it still have to be run by the compensation committee?
Well, this case was not about, gee, they earned the money, that these non-recurring gains, they were entitled to it, but they took it a month early, so therefore there was larceny. The people's theory at trial was that they weren't entitled to that money. This is what the prosecutor said in closing arguments about it. There was a number of arguments that defendants and their attorneys made to you to try to persuade you that the so-called TICOM bonus was a normal part of the process, and the so-called ADT bonus was a normal part of the bonus process. They tried to persuade you that the ordinary bonus process that the Compensation Committee engaged in every year included something called non-recurring gains. They said to you it was normal that the bonus process included non-recurring gains, recurring gains. Now, in order to make this argument, the people, the defendants, talked about the 1994 plan. And what the prosecutor then says is, I want you to take that 94 plan, I want you to go in the back and look at it. And you won't see anything in there about non-recurring gains.
Don't you still need approval of the Compensation Committee?
Well, obviously.
I mean, that's not really a technicality, is it?
Well, we believe that there was approval, and of course that brings us back to the subpoena issue, because that goes to the key question in trial, which is whether they approved it. I mean, the point I'm reading that for is to say this case was not about, well, they earned it and yet the paperwork wasn't right or they took it a month early, whatever. The people's position was these guys are making this up about bonus entitlement for non-recurring gains. I mean, what they said in their sentencing submission, which led to a sentence of 8 1/3 to 25 years, the first statement they say why a harsh sentence is required, they, the defendants, created phony cover stories for their thefts, calling them, quote, bonuses and, quote, reimbursements, stories to be parroted by their subordinates in case anyone asked questions. I know my time is up.
I know that, too, Mr.
I have some.
And of course, you have your rebuttal time. Yes. Mr. Morton?
May it please the Court, John Martin for Dennis Kozlowski, and I'd like to reserve 4 minutes for rebuttal. I want to start by talking about the testimony of David Boies, and to put that in context, which I think frames the issue, let me start with a hypothetical. Let's assume that a criminal corporate fraud trial, the defendants opened solely on with the argument that they were presumed to be innocent, and the government had the burden, or the people had the burden of proving their guilt beyond a reasonable doubt. Assume after the openings, the prosecutor said to the court, I would now like to call as my first witness Robert Fisk, the former United States Attorney for the Southern District of New York, the first of the Watergate Special Prosecutors, and have Mr. Fisk testify about the investigation of these defendants' conduct that he conducted, and to give the jury his opinions with respect to their guilt. I think if that circumstance occurred, this Court would have little problem saying that that is reversible error.
But that didn't actually happen here, did it, Mr. Martin?
I think it did in substance, Your Honor, and that's our point, that look at what happened to David Boies. I think one of the things you want to
wasn't the jury instructed that they could not view his testimony, give any greater weight because of who he was? Wasn't the jury properly instructed?
The problem is that David Boies should never have been allowed to testify about this investigation. And that investigation, the fact that he testified about it, led the prosecutor in his summation to tell the jury that David Boies saw no justification for this 1999 bonus.
Well, he's allowed to they're allowed to call him to testify that he had a meeting with Mark Swartz at which he said you've got to pay the money back?
No.
No?
Not against Dennis Kozlowski.
Oh, okay.
He had absolutely, and this is an important point.
Is there a little preservation problem here?
No.
Okay.
And the reason for that, Your Honor, is as follows. Mr. Kozlowski's trial counsel made it abundantly clear, and let me tell you how he put it in his severance motion. He's a New Yorker. He said to the court, we got nothing to do with David Boies. We didn't call Boies. We didn't bring Boies into this case. David Boies had no testimony to give against Dennis Kozlowski. Dennis Kozlowski's counsel repeatedly argued to the court that the statement with respect to what happened with his conversation with Swartz was not admissible, but he also argued that David Boies' whole testimony about its investigation was not admissible.
Well, those are two separate points, aren't they? I mean, you have a question of basically a hearsay or confrontation question as to Kozlowski. But both Swartz and Kozlowski are saying Boies shouldn't have been up there at all?
Well, I think obviously Swartz would agree that he had a right to testify as to the conversation, but I don't think...
And he has some right to testify as to how he came to be sitting there with Mr. Swartz. He has to give some background, doesn't he?
Well, let's look what happened. The first trial, David Boies testified for 3 pages. The second trial, his direct testimony is 75 pages.
And in those 75 pages, what's the closest he comes to saying, I formed an opinion that these people had stolen the money?
I think you have to look at I can't give you a line in verse. I think you have to look at it. But the easiest way to tell that is to look at the prosecutor's summation. When the prosecutor tells the jury, David Boies had found no justification for this bonus, the prosecutor tells the jury, it's only after David Boies and his investigators come in that we find out what these defendants have been doing.
Does no justification mean the same thing as they stole this money?
In the context in which it is argued, absolutely, Your Honor. I mean, that was the whole point, as Mr. Marmer just got finished talking about. The whole question was, did these people have a justification for the money, or did they steal it? So to say that there was no justification.
The jury knew that Boies was Tycho's lawyer.
Correct.
Is it really that overwhelming that Tycho's lawyer, no matter how distinguished he is, thinks that Tycho's entitled to the money back?
Let me put it another way. Suppose the prosecutor stood up in his summation, or her summation, and said, ladies and gentlemen of the jury, before this indictment was filed, we conducted a lengthy investigation, and we came to the conclusion that this indictment should be brought because these defendants were guilty. I mean, no question that's reversible error. So what they do is they simply substitute David Boies' opinion for their own opinion. So I do think that it was highly prejudicial. I want to go back again because I do think it's crucial here with respect to my client. I think it's inadmissible. The investigation is inadmissible against Mr. Swartz. The prosecutor said it was relevant to his attack on the credibility of the directors, but it really wasn't, because his attack on the credibility of the directors was not that they didn't know, which might have made the Boies investigation relevant. His argument, as you heard, was they did know, and still they paid him all this money. So Boies' investigation was not relevant against Swartz, but it's certainly not relevant against my client, whose lawyer actually said to the court, look, even if you think this is somehow admissible against Swartz, it's not admissible against Kozlowski. I asked Kozlowski no questions. We want an instruction that this is not admissible against Dennis Kozlowski. That was denied. So all of this comes in.
So can you describe the scenario on which the jury might have acquitted Kozlowski if it had not heard about the Boies-Swartz conversation?
Well, the critical to the defense was that these bonuses were earned, that in most instances they had been approved by Mr. Hampton, who was a deceased director. Now, in support of that argument, there were contemporaneous documents in which reflected the fact that Kozlowski said, while Hampton was alive, that he had approved these.
But these are Kozlowski saying that, not...
Yeah, absolutely. But saying it at the time, when Hampton was alive, to people who could have told this to Hampton. I'm saying it's not simply something that came up after Hampton died. And I think that is significant. Now, sure, could the jury...
The statement of which you complain is essentially that Boies says to Swartz, what are you doing taking this money? And Swartz is saying, Kozlowski told me to, right?
Right.
But your defense isn't that he didn't take it or that Kozlowski didn't tell him to or that he didn't know about it. It's that they were entitled to it. So what's the problem?
The problem is the people say, look, all Boys did was confirm the fact that Kozlowski authorized this payment. That's not what he said. He said, Kozlowski told me to do it. And what did Kozlowski tell him to do? Take a bonus to which he wasn't entitled. That was the thrust of the testimony. So it isn't simply that he authorized some proper bonus. It wasn't that he authorized him to do it. He told me to do it.
But does the jury, how likely is it the jury is going to convict Kozlowski because Swartz, talking to Boys at a time when Swartz is on the hot seat, says Kozlowski told me to do it, when you admit that Kozlowski knew about it and received the benefit of it and was aware of it? Well, you know, why is that such a devastating piece of evidence?
Because it is an admission by Swartz that this was wrong. It's saying that Kozlowski is part of this wrong. And it's, you know, it's like any confession that comes in against a non-declarant. It's a confession of a co-defendant that implicates the defendant. I mean, it's very hard, you know, looking back to say what would the jury have done. But this was a case that we submit was a close case. Both defendants testified in their own behalf. Mr. Kozlowski's credibility was crucial. To the extent that Swartz undermined Kozlowski's credibility, that really just devastated his defense.
Well, there were other things that undermined the credibility, too, right?
As in every criminal
Director
case.
Walsh's testimony.
As in every criminal case, Your Honor, there is evidence going on both sides. I mean, in People v. Hardy, for example, this Court reversed the conviction because the one investigator was allowed to testify that it wasn't their practice regularly to pat down potential suspects. In that case, another detective testified that he searched the defendant and found narcotics on him. The defendant had testified that he hadn't been patted down, that he had been patted down in the first instance and nothing was found. Sure. Was there evidence that he was guilty? Absolutely. But the Court reversed because there was prejudice in the admission of the testimony. And that's our point here. And I think if you look at the prosecutor's summation, it does not lie in their mouth to tell you, well, this is just now a complainant's lawyer. They used David Boyes' testimony extensively to undercut the defense here. And for them to now say, oh, really wasn't important, didn't make any difference, we had all this other evidence, it is always hard to tell, you know, what is, how a jury would have reacted without a piece of evidence. But in this case, if you look at the prosecutor's summation, and look what I want to go back to what I was started to say before about the change in the trial. Remember, the first trial ended when the jury couldn't reach an agreement. The biggest change that the prosecution made in the presentation of the case at the second trial is that David Boyes' testimony went from 3 pages to 75 pages. He became a central witness for the prosecution, a central witness against my client, Dennis Kozlowski. And we repeatedly told the judge there should be nothing of David Boyes that comes in against Dennis Kozlowski. The judge admitted the testimony, refused any type of instruction, denied the motion for severance, all because the judge, as the appellate division found, made the erroneous ruling that Swartz's statement was a statement in furtherance of the conspiracy, when in fact it could not have been a statement in furtherance of the conspiracy since it was made after the conspiracy ended, and couldn't be in furtherance of the conspiracy since it was a confession in which he implicated Kozlowski. It wasn't an exculpatory statement in any way.
If I understand the people's argument, to some extent it's that all Boyes testified to was objective statements anyway, that it wasn't opinion, it was
the statement, I can see
fact.
no justification for this.
But
It's his opinion.
Right, but the appellate courts then said you could have subpoenaed the people that Boyes, you know, based his opinion, or his statements on, I shouldn't say opinions. Isn't that true?
Well, that has to do with the hearsay, and that's another objection to Boyes' testimony, that it's total hearsay nature. But it doesn't
Well,
solve...
he supervised that investigation.
Excuse me?
He supervised the investigation.
Absolutely.
Yeah.
But the fact that I supervise an investigation does not make what my associate in my law firm tells me anything other than hearsay.
But if he testified that he did a search of records and found no authorizations for these bonuses, you could subpoena those people those directors or those people who would be charged with the duty of authorizing those and prove him wrong.
We could have obviously tried some, but the problem is, Your Honor, our whole point of trial, and this is why I say this is clearly a preserved issue, is that he had nothing, he should not have been testifying against Kozlowski.
He did two things that you complain about that hurt your client. One is the Swartz. He recounted the Swartz hearsay statement, which you say is his hearsay is to you. The other is that he sits there for half an hour and he's David Boies and everyone's seen him on television and he's giving the jury the impression that these are bad guys. Can you really complain of that? I mean, isn't that what happens at a trial? If you have a superstar witness who has something relevant to say, you're allowed to put him on. Did he say anything that was that inflammatory?
Well, let me start by saying I don't think it was a half hour. I don't think you get I think it takes more than a half hour to get 75 pages of transcript, but I wasn't there. But beyond that, I go back to the point, David Boies shouldn't have been at a trial of Dennis Kozlowski. I think our real remedy was a severance. But if the court is going to say because of judicial economy, we're going to try and balance here, then there should have been instructions, there should have been a lot of limitations.
Was
But we
there
never got a chance for
there
that.
actually an opinion rendered, Mr. Martin? Or was it not just as Judge Piggott posed, that all David Boies related was the absence of any justification in the records?
He said there was no justification.
Period.
Period. To my view, no, he said no justification, period. Didn't say we didn't find a record of this. He said no justification. That's a period.
He quoted himself as saying that to Swartz, I guess.
But, again, you've got to put this in context, and the context is the summation of the prosecutor. Because the prosecutor then says to the jury, David Boies found no justification for this. It was only after David Boies came in and conducted his investigation that we found out about all this wrongdoing.
But wasn't the context of that argument to explain why the directors hadn't become upset sooner? Isn't it a legitimate argument in that context?
No, because it wasn't responsive to anything that my client's lawyers argued. It wasn't even responsive to what the Swartz lawyers
Weren't your clients saying, well, if we had been so bad, why were all these fine people having cocktails with us and slapping us on the back? Wasn't that part of the defense?
No. Actually, that's not. If you look at the opening, you look at the summation, you look at the cross of the – it was in one of our briefs at a different point, but it was not an argument made at trial. Simply nothing – I just go back to the fact. As to Dennis Kozlowski, David Boies shouldn't have been there. And the net result was David Boies became the most devastating witness against him, and that's why we asked this Court to reverse his conviction.
Or the jury should have been instructed to not to use his testimony against your client.
Certainly at a minimum. And, even there, I think the prejudice, the way this whole thing was done, would have still raised issues. But at a minimum, we should have gotten the instructions, which we never did.
Thank you, Mr. Martin.
Thank you very much.
Ms. Vertu?
May it please the Court, I'd like to start actually with the Boies thing, since we're on that, and I'd like to begin with the questions that you've raised about preservation, because I do think that that is a critical issue here, and it kind of explains what the judge did and how the judge did it. The first is that there was a hearsay question here about what Mr. Swartz said in that conversation. And as to that, the judge at the trial level found that it was a statement in furtherance of the conspiracy. And
the hearsay objection was preserved, wasn't it?
So that was definitely preserved. And to that extent, the defendant sought an instruction and obviously can be complaining in this Court about the fact that he didn't get one. The other question has to do more broadly with this idea that Boies appearing at all or describing his interchange with the company or describing his part of this conversation somehow conveyed an improper opinion that the jury should never have heard. And on that, the preservation issue is equally clear. This is not something the defendant raised at the second trial. In fact, it's most interesting in those terms because he did raise it at the first trial. And when he raised it at the first trial, as Judge Saparik, I think you were talking about, Then Judge Oba said, fine, absolutely, you want an instruction like that? I will tell them in no uncertain terms, Mr. Boyce's opinions are irrelevant to you. It's up to you to decide about the credibility of these witnesses and the right and wrongs of the larceny charge here.
So why didn't the judge give a similar instruction the second time?
Because he wasn't asked to. This objection on opinion grounds was never raised at the second trial, not beforehand, not during, and not after. It wasn't even raised at the summation about supposedly this was happening again in the summation. It wasn't raised then, and it wasn't in part of their request to charge. Now, that may seem a little bit odd that they're taking a different tack at the first trial and the second trial, but I think there are a couple of ways you can see the difference. One is, all the way through the second trial, during the other parts of the testimony, unpreserved claims that the defendant is raising here, Kozlowski, is saying, Boyce's opinions are getting across somehow. What was actually happening was that Mr. Swartz was doing cross-examination intended to bring the same argument in front of the jury that you've heard here today. But they kept him on all summer. If they thought he was bad, why would they be keeping him on all summer? And the judge and the people kept saying, his opinion is irrelevant. His opinion is irrelevant. Mr. Kozlowski was not chiming in at that point and saying, I agree, give an instruction because this is bad for me. Quite the opposite. On the one time he did chime in, he said, no, I expressly consent to those documents going in because they helped me. Now.
So you have no, you don't argue that Mr. Boyce did not, in fact, give an opinion?
Oh, absolutely I do, and that's exactly where I was going next.
Well, then I don't, well, it seems to contradict the statements you've just made.
Well, in terms of preservation, it seems to me what was actually happening at this trial is that the defense, and particularly Mr. Stillman and the Swartz team, were trying to leave the impression with the jury that there was a pro-defendant opinion on the Boyce team and among the directors during the summer of 2002. And part of the reason that Mr. Boyce came to testify at all, as the people explained when they called him to the judge, they said, we just need to lay out when that team actually got there, when they actually found out about things like these bonuses, so that the jury doesn't get the impression that that Mr. Swartz was kept around for month after month after month after month. Now, I think one of you pointed out that, in fact, it was within 2 weeks of the time they discovered that first bonus, and in fact, only 3 days after the new CEO came on, that they entered the agreement to get Mr. Swartz out. So it was totally different when you know exactly when things happened. So that's why they called him, to give the dates and the times of events.
How much of those 75 pages was direct examination?
The 75 pages was direct examination, and most of it was laying out when they were hired, how they were hired originally just to do the lawsuits against Mr. Walsh, how then things expanded when Mr. Kozlowski was indicted in the other case to encompass more, and other things, of course, that were...
There was some atmosphere, too. Didn't you represent the United States against Microsoft? Didn't you argue Bush v. Gore?
Yes.
You found time for that?
Definitely there was. And the reason, of course, was they already knew that the Swartz team was going to be attacking his credibility really very, very vehemently, including calling him the $45 million man, which again meant that we wanted to bring out on our direct a little bit about why the fees were so high to explain in terms of whether he had a motive to lie about this statement. Now, the interesting thing about
But he did testify that he unearthed a serious problem in the course of the investigation.
He definitely used the word serious problem.
That was not favorable testimony for the defendant.
It certainly would have been much worse if he said, I consider this a serious problem, or in my opinion, I think this is a serious problem. But that's why I want you, if anybody has any question about this, look at the difference between the first trial testimony and the second.
He said, I told him I couldn't see any justification for the entry, and unless there was something I was missing, this was a serious problem.
Right. And as I say, if he said this was a serious problem, that would be one thing. What he said
this
was
a serious problem.
Unless there's something I'm missing. He said, I went in to find out his explanation. If it's true there is no justification because we've looked through the records, we can't find it. And on that, I think it's absolutely critical that it was conceded by both defendants, Mr. Kozlowski and Mr. Swartz, both by their attorneys, both in their cross and in their own testimony, that you can look from cover to cover in the minutes of the Compensation Committee, and you are not going to find any approval for these bonuses. You are not going to find any mention of these bonuses. You are not going to find any EPS calculations about these bonuses. So when he walked in and said, we found this entry, we looked through the minutes, we don't see any justification, it doesn't appear to be authorized, unless there's something I'm missing, it's not an opinion, and it doesn't reveal any facts that the jury hadn't known.
I know you have
Literally.
Pardon me for interrupting you, and I know you have a preservation issue with this, but one of the arguments that's made is that you didn't need Boyes at all. You had the directors, you had the officers, and all of the people who were charged with the very duties that Boyes was then investigating. So if there was a compensation committee, and if there was someone in the compensation committee who was supposed to do these things, you could have called that person, and they would have said, no, here are our minutes, and there's nothing in here indicating that any of these payments were authorized. And instead, Boyes came in and made the same statements without their argument, without disclosing what would otherwise be Rosario material. And I know they don't make a big deal out of Rosario, but I know that the amicus does. And one of the questions that's interesting to me is, if there is this joint defense agreement, isn't that a problem where at least conceivably the people could say to someone, give us this material, but if you've got anything else, I just assume not see it now. Maybe later, but not now. And then when the DA, as they did in this case, says, we have no Rosario material, to me it seemed almost ambiguous. Did that mean we have no statements from Mr. Boyes? Or did it mean we have no statements from all of these people that Mr. Boyes interviewed, upon which he then based his testimony?
Well, I think
long question, I'm sorry.
With many good things in it, so I'll try to pick them up as many as I can. One of the things about this, I'll start at the beginning with Mr. Boyes' testimony. We did exactly that, what you said, put in the records themselves, called the custodian of the records and put them in. This happened thousands of pages before Mr. Boyes took the stand.
So you didn't need them?
So, well, I'll tell you why. Because we actually kept saying, Judge, make them stop cross-examining about Boyes. He's irrelevant to this trial. And the defense team, particularly the Swartz team, kept saying, no, we want to cross-examine about everything Boyes did that summer because it shows the directors aren't credible. Because the issue here came down to, if you look at the pieces of paper, there is no justification for these bonuses. What it came down to was a credibility battle between the defendants saying, well, we didn't write it down anywhere, but they all knew about it. And the director saying, we never heard about it. And it became critical how long they kept them after. This was the whole focus. In the opening statement of Mr. Swartz, he said, the most important thing is going to be the summer of 2002. And witness after witness after witness after witness, the cross was done in a way that made it seem like that Boyes had unearthed these bonuses in June, or maybe even earlier, who knew, and that nobody did anything for months. They sat around and it was all okay. And it was only when the DA indicted that suddenly everybody changed their mind. So it was very important to lay that to rest, which I think also brings me back to the summation arguments you've heard here. Because in the summation points that they're pointing to are Kozlowski's own summation and our response to it. In that part of the summation, that was exactly the argument being made by both defendants and Mr. Kozlowski, that the directors changed their story when the DA indicted. And the response to that obviously did point to Mr. Boyes, because instead what they show is within a couple of weeks, Mr. Swartz was out on his ear. They found those bonuses, and they acted from that point totally consistently with the way you would expect.
If it was a central issue in the case as to whether the directors changed their story when the DA indicted, why shouldn't they be allowed to have interviews with those witnesses that took place before the indictment?
In terms of the interviews they had in mid-August, there are two things that I think are critical. One, The DA indicting happened in September, so that's like,
And
that's long after.
the interviews were in June and August.
Are in mid-August.
And
Well-
shouldn't they be entitled to look at them and see were these directors indeed telling a different story in June and August from what they're telling now?
Well, they can if they can make some showing that they're not on a pure fishing expedition for the mere possibility
Well, how
of
can they do that
impeachment material.
if no one has seen these documents? I mean, there was never any in-camera review of these documents.
Well, I think that there are lots of ways in a case in which there is any evidence of inconsistency or shifting of positions, not on allegiance to the defendants. Obviously, their allegiance shifted to the defendants, away from the defendants once they found out about these bonuses. That doesn't help. But if there was anything you could point to show...
As a normal rule, putting aside work product and attorney-client privilege, you're not seriously saying that if a witness gets on the stand and the defense knows there's a memorandum in which he's been interviewed on the very subject of his testimony, they can subpoena the memorandum, can't they?
Well, it seems to me that, first, the question is that makes it relevant. That makes it Rosario material. Rosario material, obviously, the standard is it's about the subject matter.
I mean, what's the are you really it's not Rosario material if the prosecution doesn't have it.
Right. But
suppose
that's,
the third part. I mean, suppose there were no. Suppose the privilege claim here were waived. Suppose there was no assertion of attorney-client or work product privilege. You're not saying that they can't subpoena these documents, are you?
Then, actually, I think if there was no if they actually made a showing that it was likely to be inconsistent.
No, that wasn't my question. Suppose they made only the showing they make now, but there's no privilege issue in the case. Are you saying they can't subpoena the documents?
Yes, absolutely, because I think Gissendoner says third parties are not, you can't get discoverable material from third parties.
What's the best case on that?
Well, Gissendoner itself says that.
Gissendoner, they were trying to subpoena the personnel records of the police.
Absolutely, but
Isn't that a little different?
The standard, yes, it's different, but it's still a fishing expedition.
Well, they said what might turn out to be favorable. I mean, they were, I mean, even though they didn't give them the personnel records, which makes an awful lot of sense to, I think, most courts, if there's something that might turn out to be favorable, I think they can get it. The Gissendoner standard here could have actually gotten them the documents, seems to me.
Well, I think it's a question of how you interpret the use of the term likelihood, which is the word that this Court used. There's, at one level, the kind of showing that would be possible, a mere possibility. And I think it's not an accident that they're characterizing their showing as potentially.
But in Gissendoner, all they had was, we want to see their personnel records because these police might be crooks. The documents had nothing to do with the facts of the case. That's a million miles from our case, isn't it?
It's definitely different in the sense that this could be impeachment material, but only, let us begin with 72 documents, only of the people who testified at the trial. And when you leave out people...
That's all they were asking for, was the interview notes of the people who testified at trial.
No, actually, Judge, that's what they've narrowed it down to now. But originally...
Okay, but let's
Okay.
deal with what we've
Well,
got
then we're
now. And
dealing-
also, Gissendoner says what might turn out to be exculpatory material. It doesn't say likely.
Actually, it also uses likely, I believe. But here's the
I'm
thing.
reading from Gissendoner.
You want to look at the two sets of documents that are left. What leaps out is they are documents recording attorney-client privilege conversations between the attorneys who are about to file the lawsuit against these defendants.
So we're now past that first issue and on to the
Well, I think
waiver
that
issue.
it definitely becomes complicated because when you start out with a subpoena asking for 72 things, some arguments apply to some parts of it and some don't.
We're down to 3
If we want to go
documents.
down to the last 3, then what we have is some kind of showing.
Shouldn't somebody have taken a look at them?
Well, I'll tell you.
I don't mean somebody, I mean a court.
Yes. And I know the judge to do that. It would be Judge Obis. But nobody asked him to do that. For example, the cases that the defendant cites now, where they're dealing with this kind of impeachment material that might turn out to be evidence if, in fact, it turned out that there was something inconsistent in there, in those cases, Reyes and Ferguson, the federal judges said, look, you can't subpoena this stuff, and we're not doing discovery here, but I will take it, and I will look at it, And I will see if there's
Why
a...
shouldn't Judge Hobus have done exactly the same thing those judges did?
As I say, they didn't ask him to do that.
I just not well. They asked him. They asked him for the same thing that people in Reyes and that other case Ferguson asked for. They asked him to subpoena the documents. In the federal cases, the judge said, "I'm not giving them to you, but I'll read them." Why shouldn't Judge Hobus have said the same thing?
Well, I think that, one, he wasn't asked to, and two, these were privileged materials, which is when you get it down to the last few documents, you are talking about documents as to which you can't put aside.
Shouldn't he have
the
made
work-
that determination, Judge Obus? Could he, I mean,
About whether it was...
We're talking about 3 documents here, 28 pages, 3 documents. So
Okay,
that's
now
what
that we're down to that...
All right.
Now that we're down to
And
that...
are we talking about absolutely privileged or qualifiedly privileged?
Well, I think we should go back to the defendant's concession in front of Judge Obus, which is the Tyco attorneys came in and said, these are attorney-client privileged conversations. These are absolutely privileged, and they are trial prep. And the defendant conceded that the first 2 were right. So we're talking about core work product by the attorneys about to file the litigation.
But that's a 3101C argument, it seems to me.
Absolutely.
And I'm still curious about the Rosario issue. If you had interviewed these 3, you'd have had to turn them over, right?
Absolutely, and we did.
And somehow, because somebody else who has a joint defense agreement with you does that interviewing, they're...
I'm glad you came back to that, because I did want to mention that we now have this argument about the joint, the common interest agreement. This came in the reply brief here, and in fact, when you look at what they're pointing to, what the Tyco attorneys were doing was not saying we entered into some agreement, but that they considered us the victim. So we were never feeling pressured about being indicted. And, I think that makes a huge difference in terms of the facts here. But the second thing is, the question is, are you going to change the rules to make criminal discovery and the very, very narrow work product definition that applies to prosecutors and criminal defense attorneys suddenly apply to other attorneys who are preparing civil lawsuits under a completely different theory?
Well, these were prepared for a civil lawsuit.
Yes, and the question, and so when they were sitting there writing, they assumed that the subsection C definition was the one that was going to apply. And moreover...
Was there any exchange in the civil litigation of these documents?
No, they were found to be privileged, as far as I can tell. This was their privilege log. And presumably, if the defense had got them in the civil case, I assume they wouldn't be asking you for them here.
And your office never saw these 28 pages?
Absolutely not.
But did you talk to Mr. Boyes about the content?
Actually,
of
Mr.
those
Boyes,
interviews?
Mr. Boyes said flatly, as did other Tyco attorneys preparing the papers, that the content of these documents, of their work product, was never disclosed to anyone.
You're almost out of time. Are you at some point?
Apprendi? Oh, you're going to
Apprendi,
discuss the
yes.
Apprendi issue because that...
Exactly what I was going to say.
Were you going to ask that too? Okay, please,
Well-
you only have a few minutes.
Right. The two most important things, I think, about the Apprendi argument are that in order for you to reach a different decision here than you did in People Against Horn, I think you would actually have to throw over the reasoning that you used in Horn, which was not like in that Seventh Circuit case.
Horn was before Booker and Blakely were decided.
It was definitely before Booker, but I think, if anything, Booker makes it clearer that as long as there is no mandatory cap, that if you take the guidelines and make them discretionary, there's nothing at all wrong with judicial fact-finding.
Well, you say here that this was a sentence within the range?
Yes, absolutely.
What was the top of the range?
Infinity.
Oh.
Wasn't the top of the range $5,000, and anything above that would require fact-finding? And in this case, it was fact-finding by the judge as opposed to fact-finding by the jury. Isn't that the whole premise of Apprendi and
Well,
progeny?
I think that actually there are two kinds of fines, the way there are two kinds of restitution in New York. One is a capped version that can apply to any kind of restitution on that, or any kind of penalty. So, for example, if you have criminal contempt of court, a judge can impose a certain capped amount just as a flat punishment. But then there's a second kind of restitution and a second kind of fine, which is tied instead to gain and loss or medical.
It's double the gain,
And then
right?
it's double the gain, and it's totally uncapped. There is no $1 trillion cap. There is no $1 million cap.
If there were a cap, would that change the case?
If there was a cap and it went over, for example, if you
No, but
wanted...
in the guidelines cases, there's a cap, there's a maximum statutory sentence, and within that range, there are levels that are permitted by the guidelines depending on certain fact findings. Why isn't this the same thing?
It is exactly the same thing,
But
because
the guidelines
what-
were held unconstitutional.
And unless they were discretionary. If it was a mandatory cap system, if it said the judge has to impose 5 years or has to impose $1 million,
well, it wasn't.
no, because they're remedied there, all of
But
them.
even, you're saying that Booker would, the way I read Booker and Blakely, they were saying that because the judge must find certain facts in order to go over a certain threshold, that makes it bad under Apprendi. You're saying, I mean, the fact finding is required. He can't impose your infinity dollars unless he finds that infinity over 2 was the gain, right?
Yes,
And he has, and you say he can find that by preponderance of the evidence.
yes,
And that finding is essential to the sentence.
yes.
How is this different from Blakely and Booker?
Because what happens with, you have to look at what actually the Supreme Court said about the guidelines. If the guidelines were to be considered mandatory, if there was a mandatory fine, say, under one of these guidelines of $100,000, then that would be something that the jury would have to find. But if it's simply discretionary, if the guidelines exist there to guide the judge's discretion, then there's no constitutional problem. Because, Judge, it's not
That's
judicial.
to guide it within the range fixed by statute.
No, that would make it mandatory. That's exactly what they were outlawing.
Isn't that what it is today, that they're discretionary guidelines that guide the judge within a range fixed by statute?
Yes, but they're not mandatory on the
Do
judge
you also
anymore.
rely on the fact that the amount of the bonuses was not disputed?
Absolutely, Judge. It seems to me that that's why in some ways this isn't the best test case, because here there was not only an admission at the time of sentence, specifically for purposes of both restitution and fine, they admitted these very amounts.
But didn't they also, they admitted the amounts, but didn't they claim offsets?
They claimed offsets of a kind that I don't think would change anybody's view here. It's like you still have my deferred compensation. And
Whether it would change anybody, they said, I mean, Kozlowski clearly said, and I read Swartz as saying the real fine should be 0 because I have an offset.
Yes, and they also said the real fine should be 0 because I earned all of this. But that goes right back to what this Court did in Horns.
This is after they were found guilty.
Yes.
A determination that had to be made with a fact-finding hearing. There was a hearing, correct?
Right, but the defendants admitted the amounts the judge
And there were
used.
submissions that were made
Yes.
at the hearing by...
So that in that case, you know, the judge can, based on those admissions, the judge simply said there's no need for a hearing, which actually is the very last thing Mr. Swartz said as well. Those numbers.
So if the judge had said there's no need for a hearing and just imposed it, that wouldn't violate Apprendi. It's
Right, which is exactly
The fact
what
that he
we're
had to
saying.
make some fact-finding.
Right, exactly.
Thank you, Ms. Rinder. Mr. Marmer?
Thank you. I know I just have a few minutes. I'll try not to mention the clerk again. But I do. Judge Smith may have put it in the most simple way that I can imagine, which was if these directors took the stands, which they did, why are we not allowed to subpoena their prior statements? We have identified specific statements. I don't know how you can identify them better than looking at a privilege log and saying those are the statements. That's when they were made. That's who made them. That's the topic.
Do you admit that but for waiver, they would be subject to the attorney-client privilege?
Yes. No, I don't dispute that. Absolutely. But appreciate what happened here, which is that every time the Tyco took a position about privilege, they switched it when the people asked.
Okay, but not just trial preparation materials. You say that you acknowledge that these were at the time they were given attorney-client?
They were absolutely attorney-client. The attorney-client privilege, I think we briefed it well, I think was largely.
If we find that that privilege was not waived, then the rest of the argument becomes academic.
I suppose that's right, although I think the argument that it was either waived or let me come back to this one second. And the people, I think, essentially abandoned any reliance on it. What happened below is the following. Mark Swartz himself gives statements, a written statement, a statement that's written down by Boyd Schiller. He also gives an oral statement to David Boyd. Of course, we say he didn't say what Boyd said, but put that aside. We actually subpoenaed those written statements. And what does Boies Schiller say? Those are privileged. They're attorney-client privilege, and they are the purest form of work product. We don't get them. Then what happens? The people come along and say, between trials, we got to shore up this second trial. We need David Boies. Or actually, I guess at the end of the first trial, we need David Boies. What happens? Tyco switches positions. That's not attorney-client privilege, Your Honor. There's no waiver. Why? Well, because Mark Swartz was outside the privilege. He was a subject of our investigation. Now, I don't know what that means. He's still the CFO of the company. But what's important is that every one of those directors and officers were the subjects of that same internal investigation. They said, we want Boies Schiller to investigate us.
Mr. Marmer, I don't want to interrupt your response to Judge Smith, but you have skipped very lightly over the Gissendaner standard and proposed a new standard.
And I do want to come back to that, Your Honor, if I may, because it does seem that the Court
Because
is
we don't
focused.
get to the privilege and waiver issues unless you've satisfied this standard.
Judge Smith asked my adversary, what's your best case? We cited a number of cases, I think, under Gissendaner, where there was privilege, where there was no privilege, all of which focused on prior statements of witnesses. And we said, here's a bunch of cases. They're very similar. They overcome the privilege. People do not cite a single case, not one case in their brief, 200 pages, nor did they cite one in response to Judge Smith's question. I don't think there is a single case out there that is even remotely close to this in terms of denial of process to a defendant who seeks that kind of material.
But you were, in effect, arguing for a Rosario standard.
I'm not arguing. I think a Rosario-like standard is potentially appropriate in light of what, the question that was posed. It's a prior statement by a witness. Okay. But we did so much more than that, right? We showed that these are prior statements by the key witnesses in this case, talking about the key issues in this case. They were made at a time before the motives we think had changed. They are the only statements recorded at that time. Moreover, we established objective facts to show that at the very least, whether we want to say the directors were supporting Mark Swartz or whether they were moving him on out, they were taking actions with respect to Mark Swartz on August 12th and August 13th, 2002, that are inconsistent with the notion that he stole money from that company. We marshaled as many of those facts that we could to show that. We showed that at that time, after the statements were made, he was designated to sign and attest to the accuracy of Tyco's 10Q, its SEC document. He continued as CFO through September of 2002. He ran investor conference calls as the financial spokesman of this company. He also he did get $50 million. We can debate whether it should have been more or less, but even the people's position doesn't make a lot of sense because Tyco sued him 2 weeks later, 3 weeks later, after the DA came down on them, to get that money back.
Did you argue to the judge that he should at least take a look at the documents?
We subpoenaed the documents, which I think by definition is a request that the judge take custody of them and look at them.
That's it? You didn't ask for an
in-camera? We did not
in-camera?
ask him specifically for that, but the case law is clear that it is a tool at the judge's discretion to look at them if he believes he needs help in resolving that question. I think this Court said in the Combest case, I just have it right here in the footnote, we note that while a court is not always required to review subpoenaed material in camera in order to determine in the first instance whether the requisite showing has been made, in this case it would have been the better practice to do so. But it says the court should also be mindful in a criminal case that omissions, contrasts, and even contradictions vital for discrediting a witness are certainly not as apparent to the impartial presiding judge as to the single-minded counsel for the accused. Quoting
What would the
Rosario.
remedy be here if we were to find that there should have been at least an in-camera inspection? Would it be a reversal or would it be some sort of conditional?
Right. That's a good question.
Could it be sent back just for an in-camera review?
Well, I believe the court can
And if
fashion.
there's nothing there, there's
Well, again, I guess I would point to the Combest case. In the Combest case, there was a subpoena for a videotape, which I believe neither the trial court had looked at nor this court, and there was a reversal there. Now, we have subpoenaed, without an in-camera review, there was a reversal of that case outright. In this case, we have subpoenaed 28 pages of notes of the key witnesses. So I think that that evidence is dramatically helpful for the defendant, as that videotape was potentially for the defendant in that case. So I do ask for a reversal. And in saying that, I want to point out that the error here is not just the statements taken alone, by themselves, that we didn't get them. It is the pattern and practice of Tyco and the people allowing into evidence material from the internal investigation that helped one side, while at the same time denying the defense access to the material that would have helped them. You can't conduct an internal investigation and say, well, we'll give you the stuff that's going to help convict the defendant, but we're not going to give the defendant the stuff that might help him.
Thank you, Mr.
Thank
Martin.
you.
Mr. Martin?
I'll hope to be brief. I want to respond to a statement that counsel for the people made that somehow the arguments of the prosecutors in summation with respect to Boies was responsive to something that Mr. Kozlowski's counsel did. They make that same statement in the brief at page 144, and they cite 4 pages of the transcript with 15,439 to 43. You read those pages, it is clear that the only argument counsel for the defendant made was that these directives were motivated because of their own concerns about civil liability. There was testimony about a change of economic times, but that was an argument, but that was addressed solely to the jury's consideration of the contributions that Mr. Kozlowski made to Tyco, and counsel was saying, don't look at the fact that as a result of the change of economic times, a lot of those decisions didn't prove to be worthwhile. There was nothing relating to Boies' testimony. I just ask you to look at those pages. Again, I want to just mention again on the preservation argument. Our preservation argument is very simple. We told the court every way we could that David Boies' testimony, none of it, should come in against Mr. Kozlowski. We objected to his investigation. We objected to the statements with respect to Mr. Swartz. We objected to everything. We moved for severance. We moved for mistrial. We made it clear that none of this should have been in there.
Did you make the argument that he's in substance given an opinion on guilt?
That argument was not made at the second trial, Your Honor. There's some mention of it at the earlier trial. But the point is, you don't get to the opinion if you don't get his testimony in against Kozlowski. And our whole point was, none of this comes in. We're getting killed by it. And we also made the point, and it's been reinforced here. The prosecution says, well, this is all comes in against Swartz. Swartz did this. We said to Judge Obis, even if it comes in against Swartz, we're entitled to at least an instruction that it's not relevant as to Kozlowski. We never got that. I submit that when you're dealing with a situation of 2 defendants being tried, there's a responsibility of the court when it's not admissible against one defendant to make that clear to the jury at a minimum. And I think where it is this prejudicial, as I said, I thought I would submit that a motion for severance should have been granted. But in any event, I don't see how you could preserve any more clearly the claim that none of what David Boies said, not his opinion, not anything, not a word that he said, should have come in against Kozlowski. Thank you very much.
Thank you.